I think we talked about it.
We talked about that, I believe, that's the van.
It's the van. It's
After sentencing judge, the state would not approve that.
Okay. All right. So are you then asking that the motion for return of property be continued until February 13th?
Yes, that's fine, Your Honor. We're here for today on a motion to reduce bond.
Right. We go one thing at a time.
I'm sorry, I didn't know if it was
Yeah.
before the court, and I have a copy here.
So first things first, the motion of return of property, you're asking that be continued to February 13th?
That's fine with me, Your Honor, unless the court wants to sign an order post-dating it until after
Oh,
sentencing.
I don't post date.
I understand.
All right.
Yes, we're fine with continuing that.
All right. And then the next thing we have is a motion to reduce bond. State, have you had a chance to review the request for a motion to reduce bond?
No, but we're aware of, we've talked to the defense counsel about the, what he's asking. And actually, I'm reviewing it right now, Your Honor. He gave me a copy.
All right.
So yes, we're prepared to go forward.
All right. Defense?
Your Honor, we have a witness we would like to call on support of the motion.
All right. If you'll call your witness.
We would call Yvette Teller.
Sorry, Yvette.
Teller. Teller.
All right. And you'll need to, I think, what do you want him to step?
Mr. Dale, this side.
Good morning. If you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, I'm going to need you to keep your voice up so that I can hear you and the court reporter can hear you. All right. Defense?
Thank you, Your Honor. Yvette, would you please identify yourself and your relation to Michael?
I'm Michael's older sister.
Okay. And you're aware as to the charges that are against Michael, is that right?
Yes.
And you're aware that he has already entered into a plea?
Yes.
Okay. And are you aware that he is set for sentencing next week?
Yes.
Why we are here is because we have a motion before the court requesting that they reduce his bond amount. Are you aware that there has been a bond in place on this case for almost a year?
Yes.
Okay, and you're aware that the amount on that is, I believe, $70,000?
Quick pause here. What you're watching is not sentencing yet. This is a bond reduction hearing. Translation: the defense is asking the judge for temporary freedom before sentencing. And in Texas, once a defendant has already pled guilty, this kind of request is an uphill climb.
Do you want to have the court reconsider the bond amount?
I do.
Okay, and could you tell us why?
Your Honor, Michael has two daughters. He's divorced, his wife remarried and had more children. Last year, one of her babies died, a 9-month-old. It was a twin baby, suffocated. My sister-in-law is doing okay, but obviously struggling, suffering. His oldest daughter is 18, his youngest is 13, just hitting puberty. There's a lot going on emotionally with them. He's always been a very involved father, very active father. Again, we understand what's going on with the court, but we asked if there was any way you could reconsider, just so he could spend a little bit of time with his girl.
If Michael were to be released, do you know where he would stay?
Yeah, he would stay at one of my houses. One of my aunts lives there. She's elderly. She's 80 years old. It's a big house. It's enough room for him to be there, to stay with his daughters, to see my father. My father's 73. If he ends up doing his 10 years, my father will be 83. God willing, he'll still be alive, but there's no guarantee with that either. So it would be enough room for him to be able to visit and just take care of any affairs that we need to put in place with his daughters and with my father.
Okay. And with Michael being able to stay at your house, would you be willing to assure the court that you would assist in making sure that Michael does everything he's supposed to do and appears back in courts on Monday?
Yes, absolutely.
Okay, we'll pass the witness.
All right, state.
Yes, Your Honor. Ma'am, are you aware of why, your brother's, bond was increased?
I'm not so,
Would it be surprising to you that he failed to appear to court?
oh, no,
If that doesn't surprise you,
well, no, because I know that he did not come to court.
he didn't come to court.
Yeah.
And so why would, the judge reduce it from the current bond if he didn't fail to show?
Because one, I'm asking for the judge to reconsider it. But you're asking me why, that's why. I don't, you're saying that if he didn't show up, if I knew that, I do know that, I know he didn't show up.
For over a year.
And at that point, sir, I was not, the person responsible
This is
for
where the
making sure.
courtroom temperature drops. You're hearing family testimony, but legally, emotional hardship alone doesn't override one massive factor: flight risk. And this defendant already failed to appear in court once. That fact is about to become the elephant in the room.
Did consider pulling money out of his 401k, but we did have to pay attorney fees as well. So we had to decide where that money would go, and that's where it went.
So you do have savings that could be used for a bond note?
We do, but not enough to cover I guess right now they're asking for $70,000, so we don't have that.
A bondsman's not asking for $70,000. It's a portion of that.
Other portion for
Right. How much is that portion? Have you talked to any bondsmen?
we have. I don't have anything written down in front of me, but yes, we have.
How many?
Mhm. I don't know, so I couldn't tell you. I honestly couldn't tell you, but there have been more than one, obviously, because before he had the other charges that he had, and those are not there anymore. So they've changed. Everything has changed. But if you want to know, have we called people? Absolutely have. We were actually asked to wait until there was the hearing, the bond reduction hearing, and they asked.
And there it is. When the state mentions that he skipped court for over a year, the bond argument takes a serious hit. Judges treat missed court dates as flashing red warning lights. It tells the court this person might disappear. Would you trust release?
Cases that they told us on the phone, they say that everything needs to be cleared up in court, and we had to come here so everything could be cleared up.
So cases that were, in a sense, taken into consideration for a plea on this case. Are you aware of that?
Yes,
Okay. And you said several houses. You stated several houses. Do you have several houses?
I don't have several, I have more than one.
More than one. Did you ever look into maybe taking a mortgage out or anything like that, or borrowing against that to get your brother out of jail for the 1
No.
week? No? Okay. No further questions, John.
Any further questions?
Just a few. Yvette, when you're talking about these other cases, is it possible that you could be talking about this same failure to stop Miranda raid because it was dismissed and re-indicted multiple times?
Yes, and I don't quite understand all of it. I don't understand how it was dismissed, and then this is not for my area of specialty is that, so I don't know exactly what happened, but I know that there's been a lot that's happened with this,
Right.
so I don't know.
And we have filed a motion to reduce bond, I believe, back in September of last year. And I think that's when we had tried. Is that when you had tried to contact these bondsmen and try and arrange everything?
At that point, I think my father was the one who had done that. I did not do that. This time around is
Okay.
when I had some people help me to call around. Just again, I don't quite understand all of it, and they did. So
Okay. No further questions for this one.
All right. Thank you so much for coming in. All right. Any other witnesses?
At this point, we would like to call Michael Tello to testify and answer a few questions.
All right. Can you raise your right hand for me, please?
Yes, Your
Do
Honor.
you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record. Please keep your voice up. And everyone in the box, you're going to have to either whisper or stop talking.
Michael Taylor.
All right, defense.
Thank you, Your Honor. Michael, you've been in continuous custody for about 284 days. Is that right?
Yes, sir.
Okay. And were you living in a house prior to your arrest?
Yes, sir.
Okay. Is that house still available to you?
Because I've been incarcerated for so long, I haven't been paying the bills, so I lost the house.
Okay. Did you have property left there?
Yes, sir.
Okay. What has happened to that property?
The landlord has been considerate enough to hold it for me until, everybody was hoping I could come home. I could pick up my carpet, but other than that, I have to move from there, really big.
Okay. Would being out for this short amount of time, would that allow you to take care of some things that have been building up for you while you've been awaiting the resolution of this case? Okay. And you do understand that you have already entered into a plea agreement?
Yes, sir. I'm taking that.
Do you understand that if the judge were to grant the motion and to reduce your bond and to allow you to go out, if you were to not show up on Monday, that the judge would not have to honor that plea agreement?
Yes, I understand that, sir.
Okay. And do you understand that that is a likely fear in the court and from the state because of the fact that you have failed to appear before?
Yes, sir. I
Okay.
understand that.
Is there anything that you would like to say to the court to address that?
I made one bad decision after another. I can honestly say that this time being in for the continuous 284 days, that I don't want to violate the agreement that I've come to. Me and the state and my attorney have come to an agreement, and I feel like it's my responsibility to go ahead and fulfill that agreement. So I don't want to violate it, and I just want to get this done with. Get on with my life now.
Okay. And what other things would you be able to take care of if you had the ability to be out on?
As of right now, I've asked my sister and my father to see if they could help me with my BA benefits, but because it's not me, they can do it for me. This is something that I will be able to approach and handle firsthand if I was released out. So, I mean, that's one thing other than trying to do with my kids.
Okay. We'll pass the witness.
Okay.
All right. Any other witnesses?
No further witnesses, just argument.
All right, Mr. Teo, what I can tell you is with regards to the VA, I mean, there are good things about it, of course, but it works very slowly. And I don't see anything being accomplished in a week with the VA. Your motion for bond reduction is denied. Counsel, would you prefer to go ahead with sentencing now, or you want to come back on the 13th?
I think we'd like to come back on the 13th. Just I think the main issue was the victim statement.
Yes, Your Honor, the victim's family would like to be present.
Okay.
And that's one reason that after everything, the victim.
Okay. All right. And your client's in the middle, if you can. Court is calling 2022 CR 8111, State of Texas versus Michael Teo. Could I have parties announced for the record for the state?
Jason Dorkins for the state.
For the defense?
Andres Campion for the defense.
And are you Mr. Teo?
Yes, Your Honor.
All right. You entered a plea on January 17th to count one. You entered a plea of guilty. The court found there was sufficient evidence to find you guilty. Count two was waived without objection, and so was the enhancement. According to the plea bargain agreement, punishments be assessed at 10 years in the prison. Are both parties ready to proceed? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Defense, anything you wish to say on behalf of your client?
We would ask the court to allow Mr. Teo allocution, and then we have our.
All right. You want to raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Michael Thayer.
All right, what would you like to say?
To begin with, my condolences, my most respect to the family of Mr. Neal. I'm guilty. I failed to render aid. I can replay the incident in my head.
The judge has officially denied bond reduction. Translation: he stays in custody until sentencing. Now the entire case pivots from can he go home to how much time will he serve? And that shift changes everything.
I understand that I have to take responsibility for my action. That's it, Your Honor.
All right, thank you.
Your Honor, we would just have argument. The defendant is charged under the failure to stop or render aid statute resulting in death. It is counsel's belief that the that the legislative intent behind that statute was not particularly to govern a situation that happened in this case. Back on the 1st of July of 2019, this was during the construction that was still going on that was heavily around the 151 and 410 interchange south of Petrenko. And because of all that construction, the various entrances and exits to the highways were closed, and people were forced to take, instead of a turnaround, to go through a light and come back around. And it was at the intersection where the turnaround was closed that the incident took place. And unfortunately, given the circumstances, this was in the saddest way to express this, an accident. There was no mens rea or mental culpability by Michael involving this, except for leaving the scene and being an individual who failed to stop and give assistance. According to the evidence, and from what I've seen, the first person on the scene, who was an individual behind the decedent, was a woman who had been a nurse for over 20 years, I believe. And she was immediately on scene and was able to provide whatever medical measures were necessary. This was a highly trafficked area, and due to the city statutes and city laws and requirements, there was off-duty law enforcement around the scene because there was construction going on. That's required by the municipal code. And so there were multiple individuals that were immediately there, present around the scene, and that could have administered far superior aid than Mr. Tello could have on the date in question. And I don't believe that there is anything that Michael could have done that would have changed the outcome that happened to, unfortunately, that happened to Mr. Neal. I think that even though Mr. Teo did drive through that intersection, he wasn't the individual that made the contact. His vehicle was struck, and that's not to put blame on Mr. Neal. That is just to show the court that Mr. Teo was not the individual that tried to take the decedent off of the road. He didn't swerve into him. There wasn't any aggressive actions taken by the defendants against the decedent, and that is the only purpose for which that I inform the court or make that type of argument, not to put any blame on the decedent. I know that Mr. Teo is remorseful for his actions. He has reminded me that on multiple times when we've had interactions with each other, and when he's helped me prepare for this case. And I do believe that is the legislative intent behind the statute to govern a situation on a farm to market road or a rural county road or something where there is not high traffic, where the state wants to discourage individuals from leaving the scene and leaving somebody there to bleed out without any shot or of help. However, that wasn't the case surrounding this incident. I don't believe the DA's office thought this was murder or homicide or manslaughter, because none of those charges came down. None of them were presented to a grand jury. And I believe that if the DA's office had believed that to be the case, they would have filed such charges. This is, in the truest form, a terrible, terrible accident. And we understand that everybody here has a duty that needs to be performed, and we ask that the court do nothing over the top other than to follow the agreement. And we would ask that that be done with the understanding that Mr. Teo is remorseful and has pled guilty and understands the gravity of the actions that were taken by him that resulted in the loss of life.
Okay. Anything from the state?
Your Honor, we just asked the court to follow your question.
All right. Court will find you guilty as previously stated. The court will sentence you to 10 years in the prison, give you credit for any time served. taking consideration 2019 CR 12685, 2022 CR 5759, and 2022 CR 5760. Is there anything else from either side with regards to sentencing?
Your Honor, we have, I believe, 3 victim impact statements.
All right, do you have the dismissals? Or have those already been tendered?
I think those were previously.
All right. Mr. Chair, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. All right, the next issue is the motion for return of property. My understanding is the state is in agreement that the property be returned to the defendant's father, and it is the 1993 Ford Econoline EF-150. Is that correct?
That's correct, Your Honor.
All right, the court will sign that order. We can go off the record. Mr. Teo, how old are you?
I'm 39, Your Honor.
All right, I see that you're very remorseful. This is what you have to understand. You're not super young. Sometimes people can understand if it's an 18-year-old, 17-year-old, they're not really expert drivers or have been driving long. So maybe it's shock. Let me run home to mom and dad and see what we can fix with this problem. But, you know, the law is the law. If it says you have to stop and render aid, even if that aid is calling somebody and say, hey.
10 years in prison. This sentence comes from a negotiated plea deal, meaning both sides agreed to this punishment. It also removes the defendant's right to appeal. That makes this judgment final. No redo. No second round.
Is it okay?
Okay, Your Honor.
All right, thank you. All right, State?
Thank you, Your Honor.
But no, you acted like a 2-year-old child and ran and hid. Then you came in this court and asked them to let you go. You run and hide. You come back in this court. Oh, I've got 3 daughters I have to support. You run and hide. Do you know how much I hate you at this moment? And I could hurt you. And I'm a very forgiving person. I've never had this kind of hatred before. And how every answer is to stand over here and let you look at me. This is the first time I've ever seen you show any emotion, except for when they were pleading this 10-year thing. It's a bunch of shit, but I gotta take it. So to sit there and believe that you're actually worried, you're not worried, you're not sorry. You're scared for yourself. A true man is like my husband. He did 15 years and I'm 21 years in the Air Force, taking care of other people, putting braces on them so they could walk, helping them get through surgery, giving, every ounce, giving. That's a man. Then turn around and do 15 years civil service, still giving up leave to people that needed it, money that needed it, a shoulder to lean on. This main provider for our family. The love of my life. 35 and a half years with that man. And you leave him on the road like a side piece of trash. And I'm supposed to
The
have
most powerful part of the hearing. Victim impact statements are where grief, anger, and loss are allowed to speak directly to the defendant. What you're about to hear is not legal argument. It's raw consequence.